Hello everybody, and welcome back. As promised last time, we left off with the first part of Amendment 1, and this time, we are going to start with the second half. Now, as a fair warning, I may end up being cranky as of the next video, or I may be extremely happy. We're going to find out. Because I'm starting one of those, a couple of friends recommended it to me and I wouldn't try it unless they had, Dr. Oz 3-day cleanse thing. So I'm not going to be eating actual food for the next couple of days. It's just going to be like smoothies, stuff that you make from like, berries, kale, and other things that my body just says, no, you don't want that too. So either I will be ridiculously skinny and very peppy next time, or I will be angry and trying to hunt down Dr. Oz to get him to give me back my $80. So, in the meantime, we can just go right ahead to the second half of Amendment 1. The second half of Amendment 1 continues that Congress shall make no law, quote, abridging the freedom of speech or of the press or of the right of the people peaceably to assemble and to petition the government for a redress of grievances, end quote. Now, there's not a whole lot that's all that confusing about the latter two prohibitions on Congress, that is, those concerning the right of the people peaceably to assemble and to petition the government for a redress of grievances. Common sense and even the most rudimentary knowledge of history and American political thought show that these mean, respectively, the ability for persons to meet in groups so long as their intentions are peaceful, and the ability for citizens who have suffered some injustice, such as property damage, etc., to ask the government to make restitution for damages incurred thereby. It can't just be my car got destroyed in a hurricane, the government owes me. No. If the government causes damage, then they have a right to ask for redress of grievances. It is the former two, the abridgment of the freedom of speech or of the press, that are the source of much more legal misinterpretation and confusion. Now, to begin, the phrase, the freedom of speech, is unique to American legal history. The phrase cannot be found anywhere in the English common law from which America's legal tradition stems. That being said, it is not a term of art in the most proper sense. One of the few times, if not the only time, because I have searched far and wide, that the phrase was used prior to being enshrined in Amendment 1 was in Pennsylvania's State Bill of Rights. Following the example of Virginia's State Bill of Rights, which was proposed and ratified in 1776, Pennsylvania created its own version of the document, but included, to quote Morrison, quote, stronger statements than Virginia on religious liberty, and added freedom of speech to Virginia's freedom of the press, end quote. Now, once we know this, we can proceed from the historical to the interpretational stage of the inquiry, and Russell Kirk posed the question and responded well in his book, Rights and Duties, Reflections on Our Conservative Constitution, where he said, quote, what is meant by the freedom of speech or of the press? The article here, meaning the word the, signifies the degree of freedom of speech and press that already was prevalent throughout the 13 states in 1789, or perhaps the degree of freedom of speech and press that had prevailed in Britain and the British North American colonies since 1689. The First Amendment, that is, does not affirm any absolute, total right to speak and print, end quote. Now, just real quick, the reference to 1689 was when England instituted its own Bill of Rights. So exactly 100 years later, we had our own. And moving on, Kirk correctly states that Amendment 1 was never intended to allow people to run about writing and printing or saying whatever they pleased as if they had a license to do so. The notion that somehow encapsulated within the language of this amendment there is also an inherent right to freedom of expression is an invention of the modern liberal court system. Now, also false, given the fixed nature of a written constitutional text, is the idea that over the years the people may gain new rights that fit under the protection of Amendment 1 at a federal court's say-so. So, what were the restrictions originally placed on the freedom of speech or of the press? Since, as previously stated, there is little, if any, legal precedent pertaining to the phrase, the freedom of speech, the best possible approach is to examine the rules governing the freedom of the press and then apply them to speech as best we can. At the outset of our search, we can look to political historian David Lowenthal, who stated emphatically in his work, Present Dangers, Rediscovering the First Amendment, that, quote, the American framers held that the word freedom or liberty was a term of distinction to be contrasted with license or the abuse of liberty, end quote. So, how did the founding generation understand and regard the freedom of speech and of the press? Citing Lowenthal again, he wrote that, quote, at the time of the passage of the First Amendment and the whole Bill of Rights in 1791, not only was discourse about the freedom of speech and press overwhelmingly Blackstonian, but the guarantees written into state constitutions of the day were either stated in explicitly Blackstonian terms or understood in that way. Abuses of the press or libels were not part of the freedom of the press and were therefore subject to prosecution, end quote. Now, thus, we can once again return to the legal prowess of Judge Sir William Blackstone for assistance. I love that man, seriously. I highly recommend the Commentaries on the Laws of England. Please, seriously, go out and just glance through it if you ever have any questions about the Constitution. By and large portions of your answers will be found therein. To affirm the truth of Lowenthal's statement, Blackstone said that libel is the sole exception to the freedom of the press, regardless of the degree of truth or falsity that it contains. And that was in his third volume of Private Wrongs. In his commentaries, he wrote that there are 6 different types of libel. Quote, blasphemous, immoral, treasonable, schismatical, seditious, and scandalous, end quote. All of which, again, this time we're quoting Blackstone from his volume 4, all of which, quote, are punished by the English law, some with a greater, others with a less degree of severity. The liberty of the press, properly understood, is by no means infringed or violated. The liberty of the press is indeed essential to the nature of a free state, but this consists in laying no previous restraints upon publications, and not in freedom from censure or criminal matter when published, end quote. Now, there's a pretty big distinction. It seems nitpicky at first, but it actually is pretty important. He says that, again, you are not free from censure for criminal matter when published. That is different from censure. Censure, C-E-N-S-U-R-E, means punishment for something after the fact. Censor, C-E-N-S-O-R, is to put a prior restraint on something. Like, if someone were to go through your works before he published it and cross out the things he didn't like or found offensive or whatever, that would be censoring. But if someone prints or says something libelous, or if it's spoken, scandalous, and then is punished after the fact, that is censure. And that is okay. Censor? No. Censure? Yes. Now, we have in our possession the meaning of the term of art, the liberty or freedom of the press, and it is the right to publish works without prior abridgment by the state, though the publisher may be punished ex post facto for any libelous material. However, there's one sort of tag-on question that we now have to answer, or rather, technically 6. What is meant by blasphemous, immoral, etc., libel? The answers are spread throughout the several pages on libel in Blackstone's commentaries, and for the sake of efficiency, it would be far easier to cite an already compiled series of explanations. I'm taking this from David Lowenthal again, but I also did look up all of his definitions that he took from Blackstone, and they would all be from Volume 4, specifically page 150 in the text I'm using. And he hasn't changed anything, so this is actually reliable. He's a secondary source, but I went back and checked the primary source, and it is indeed solid. There's a continuous string there of proof, so it's good. I give it 2 thumbs, way up. Lowenthal, writing of the 6 categories of libel, said that, quote, the first, blasphemous libel, and 4th, schismatical libel, arose from the existence of an established church in England. Immoral libel involved, for the most part, what we now call obscenity. And the scandalous libel seems the same as what we call ordinary libel. This leaves seditious and treasonable libel, the 2 preeminently political forms of the abuse of speech and press. Seditious libel was the political counterpart of scandalous libel. In fact, the word libel was often used to denote what was common to both, signifying malicious defamations of any person, and especially a magistrate, made public by either printing, writing, signs, or pictures in order to provoke him to wrath or expose him to public hatred, contempt, or ridicule," end quote. Now, with that said, we can understand and appreciate the First Amendment's language pertaining to the freedom of the press. Publications were indeed punishable by civil authority if they contained material contrary to the precepts of the Church of England, though in the United States, since there was and still is an obvious plurality of religious belief, this extends more or less to the precepts of Christianity in general, so it's a little harder to apply here, and I'll grant that. But material that incited social unrest and dissatisfaction, which would lead to uprisings against the government, pornographic material, etc. It would seem that these same general rules would apply to the spoken word, referring back to the freedom of speech, although libel would become slander since it is now spoken. The difference between libel is that it's in print, scandal is when it's spoken. That's the major distinction there. Obviously, the government would have a hard time putting prior restraints on the spoken word unless they, say, threw you in jail and just gag you or something, but that could never happen here, could it? Stop and think about it. But it nevertheless could punish citizens under perfectly legitimate constitutional authority for uttering slander of any kind, be it blasphemous, etc., as long as it's within the federal scope. Now, the states can do what they will. I mean, they may have their own bills of rights that forbid it, in which case you're safe on the state level as well. But on the federal level, if you're, say, the District of Columbia or in some federal building or in some other location or area that is under federal jurisdiction, then you are protected by the First Amendment in this case from the federal government interfering with some kind of with your spoken word or printed publications beforehand. They can get you afterward if you do something libelous or scandalous. But other than that, you're good. It is also understood that this applies only in those cases which are directly under the jurisdiction of the federal government. The states could tighten and loosen the aforementioned standards at their leisure. States can do whatever they want, as we will see, given Amendment 10. Amendment 10, which just says that any powers not granted to the federal government are reserved or forbidden to it by the states. It's the 10th Amendment says that if there are any powers that are not granted to the federal government or prohibited to it by the states are reserved to the states respectively, I mean the individual states, not the United States as a whole, or to the people therein. So this is one of the things that does, again, if it isn't under federal scope, it goes right back to the states or the individual people, depending on the circumstance, and then they can deal with it. So at that point, we're already pretty much done with the First Amendment, and we can pick up next time with the next well-known and often misunderstood portion of the Bill of Rights, that is the Second Amendment. So with that, I suppose we can leave off till next time, and I hope that this has been informative. I know that the First Amendment is a big issue of contention nowadays, and so that's fair, that people have a lot of questions about it. But it also is important, given that we are citizens of the United States, that we not only apply the Constitution if and when it's convenient. We have to do it in all instances in order to uphold the rule of law. Otherwise, we boil everything right back down to the rule of man, which is what we wanted to avoid to begin with. If you have the federal government nowadays picking and choosing those times when it's okay to be scandalous or libelous, that right there, that's just flagrant disregard of the Constitution, and it's up to us to know what these things mean, and not just try and skew it oh so slightly so that we can help whatever cause is, however worthy it may be. We can't use it to further that cause. We have to uphold the Constitution first, so long as there is no conflict with the laws of God. And thankfully, by the grace of God, our Constitution in no way conflicts with the divine law. So in that respect, we're pretty much in the clear on that one. Now, some people may take issue with that statement and say something about slavery. I'll get to that. Don't worry. I got this covered. I know what you're thinking. Not that it's a minor issue. It was a big part of our history. But we can get to that at a later point. So I'll let you go for now, and I will see you next time, either very skinny and happy or still fat and cranky. Time will tell. So I guess at that point I could say good night, God bless, and y'all take care until next time. All right, bye-bye.